The Voting Rights Act gave us the most powerful tool to fight voter suppression. Here's why it's at risk. The Voting Rights Act of 1965 is considered the legislative crown jewel of the civil rights era. Congress passed it in response to racist policies like literacy tests and poll taxes that denied Black Americans their right to vote. The Voting Rights Act boosted voter turnout and political representation in many marginalized communities. It was so successful that Congress renewed the law multiple times with bipartisan support. But today, much of the law's power has been stripped away. So if the Voting Rights Act was so popular, why was it attacked? In 2013, the Supreme Court decided to get rid of a huge part of the Voting Rights Act in a case called Shelby County versus Holder. Before the ruling, states with a history of racial discrimination in voting had to get federal approval before changing any voting practices or policies. Now, they don't have to. In its ruling, the court pointed to Black turnout surpassing white turnout in certain states in the 2012 election. Even though this proved that the Voting Rights Act was working, the court didn't think so. The court claimed it meant that federal oversight was no longer necessary to protect the right to vote. As Justice Ruth Bader Ginsburg put in her dissent, the decision was like throwing away your umbrella in a rainstorm because you are not getting wet. Within hours of the Supreme Court's ruling, several states enacted laws making it harder to vote. These new policies have the greatest impact on people of color. The racial turnout gap, which is the difference in participation between white and non-white voters, grew. It is now wider than any point in 16 years. Since the Supreme Court's ruling in Shelby County, dozens of states together have enacted more than 100 restrictive voting laws over the past decade. When millions of voters are silenced, it's a threat to fair representation. Congress should protect the freedom to vote from restrictive state laws.